Thank you very much, Professor Taslima.
Thank you, Professor Taslima, sir, global professor. I was mentioning, you're a global professor, and I was telling to my students that, we are in an intensive training workshop. The global professor is giving so much time to us. We are very pleased, we're very happy, we really appreciate it. Okay, now the lecture is on International Humanitarian Law, a dialogue of human rights in law and practice. So International Humanitarian Law, why we need this? We'll go through that, and then I will show you a video on the International Humanitarian Law and the role of the ICRC. The New World Human Order is as yet a nascent system grappling with war and violence, proliferating terrorism and traumatic inflictions on innocent civilians. History bears witness to massacres without mercy and mass suffering consequent on lawless attacks on the wounded and dying soldiers, and victimization of women and children during armed conflicts. When nations attack nation or ethnic, tribal or religious groups, indulge in cleansing operations in an internecine scale. So it is not war between the military, it is war, where the civilians are also affected. While the voices of the clash of civilizations are echoing loud, and the so-called war on terror is influencing the fate of some communities and many groups of individuals in various countries of the world, it is appropriate to recall the humanitarian values that rally nations and peoples around them. Indeed, peace, security, faith in fundamental human rights have been the growing hunger of the human species from the dawn of history. And what we heard from Professor Taslima, that there was war, always war was there, but we are looking for peace. International humanitarian law is that branch of public international law which seeks to protect those persons who do not or no longer take part in hostilities. So they might be combatants, or they might have been, part of hostilities, but they are not now part of hostilities. And to put restrictions on the means and methods of warfare. Warfare cannot be like, you just go and bomb the whole country away. International humanitarian law is applicable in international, non-international armed conflict and internationalized armed conflict. So, all civilizations develop rules aimed at minimizing violence and placing controls on their wars by making international law a matter to be agreed between sovereigns and by basing it on state practice and consent. So everyone wants to have, some law of war. Grotius and the other founding fathers of public international law paved the way for that law to assume universal dimensions, applicable both in peacetime and in wartime, and able to transcend cultures and civilizations. However, it was the 19th century visionary, Henry Dunant, who was a true pioneer of contemporary international humanitarian law, by instigating the adoption in 1864 of the Geneva Convention for the amelioration of the condition of the wounded and sick in armed forces in the field. So who are wounded and sick, they're out of the war. That should be. Dunant and the other founders of the ICRC, International Committee of Red Crescent and Red Cross and Red Crystal, laid the cornerstone of treaty-based international humanitarian law. This treaty was revised in 1996 and again in 1929 and 1949. New conventions protecting hospital ships, prisoners of war, and civilians were adopted. The result was the 4 Geneva Conventions of 1949, which constitute the foundation of international humanitarian law in force today. Governments have also adopted series of treaties governing the conduct of hostilities. These include the Declaration of St. Petersburg of 1868, the Hague Conventions of 1899 and 1907, and the Geneva Protocol of 1925, which bans the use of chemical and bacteriological weapons. We know in the war between Iraq and Iran, they use chemical weapons. And I was at that time in Iraq. And I saw, young boys being killed in the field, just like ants or mosquitoes. It is so devastating scene that I could not eat even for this. In 1977, there was a merging of these 2 streams of international humanitarian law with the adoption of the 2 protocols additional to the 1949 Geneva Conventions, which brought up to date both the rules governing the conduct of hostilities and those protecting war victims. More recently, other important conventions and protocols were added to this already long list of treaties. As for example, the Convention on Cluster Munitions 2008, 3rd Additional Protocol to the Geneva Convention 2005, etc. The ICRC has been contributing to the promotion and development of IHL throughout its 140-year history. And when we will be seeing the video, you will see how the ICRC are also working. Pursuant to an international mandate provided to it by states, the ICRC operates in nearly 80 countries, many of which are affected by armed conflict and other situations of armed violence. In addition to its other operations, the ICRC's activities include promoting and developing the international humanitarian law in the countries in which it operates. So there must be an awareness building of IHL, international humanitarian law, what it means. Everyone must know. The ICRC mission of Bangladesh conducts several different activities designed to promote increased awareness and development of international humanitarian law. So increased awareness is needed. These include organizing seminars and conferences, developing courses in universities, training teachers, and organizing moot court competitions on topics of international humanitarian law. Every year we are doing this, moot court competitions and going into it. But before that, I want to know that, the developing courses, we have already developed courses in Dhaka University and other public universities on international humanitarian law, and teachers are also trained on international humanitarian law. So training are done, development are done, but then also, are we successful? I don't think so. You will see how people are being killed. Faculty of Law, University of Dhaka, which I represent as the Dean of the Faculty for the 4th time, feels proud to be the glorious partner of many of these programs and activities as the Henry Dunant Memorial Moot Court Competition. We do that every year. We have this Henry Dunant Memorial Moot Court Competition. All the universities of Bangladesh, they participate, and then we have the competition, and the judges are real judges from the courts, and after that, the moot court, we give awards to the winners. The principal objective of the Henry Dunant Memorial Moot Court Competition is to develop and increase awareness and interest in international humanitarian law in academic institutions throughout South Asia. The further objective is to use international humanitarian law to further academic excellence in the student community and to develop their advocacy skills in an environment of friendly competitions. That is how the moot court competitions with the IHL is done. And at the same time, a dialogue of human rights law and practice with the students. So this also brings a dialogue between the students and the judges and the teachers, the academia. So this is where, the last, not this year, last year the law students battled it out, and Dhaka University was the winner last year. But this year, Brack University is the winner. So we are doing this only for awareness building. What else can be done? By a video, you can really put it in your heart if you see what is happening and why international humanitarian law is needed. So kindly, I know I'll take 10 minutes for the video, and I hope the organizing committee is. Please see the video.
It's important to know international humanitarian law, but it's even more important to obey it and make sure that others obey it as well. In fact, this is a matter of life and death. People have been waging war since time immemorial. When an armed conflict breaks out, the law of the jungle is paramount, and civilization yields to brutality and chaos. War not only destroys precious objects and takes human lives, it wrecks the fabric of society. Everything collapses, and the brunt is always borne by civilians.
Tenía un lugar estable y lo perdí. Lo perdí todo.
Rape, plunder, ethnic cleansing, massacres, and violence of every kind are the grim spectre of war. Blood spattered and insatiable. And yet war does have limits, essential limits. They are the rules of humanitarian law. Even children playing war know the rules. These rules state how those taking part must behave and require that the adversary be respected. The early rules were a matter of custom, established by the civilizations of the day. Other rules emerged from religious and ethical sources, such as the Bible and the Quran. Modern humanitarian law was founded in 1864 at the instigation of Henri Dunant and the International Committee of the Red Cross. It enshrined one basic rule: spare anyone on the battlefield who is not taking part in the hostilities. Over time, the law's scope broadened to protect other people affected by conflict and to impose restrictions on the way war is waged. Neutral and independent, the ICRC has a mandate from the international community to promote compliance with humanitarian law. That law is specifically designed for wartime, whereas human rights law covers all situations.
The ICRC has a double responsibility. On the one hand, it has a responsibility to check and identify where violations of international humanitarian law occur and to intervene on the level of the relevant authorities to counter these violations. And on the other hand, the ICRC also has a role to clarify and develop international humanitarian law when necessary.
The Geneva Conventions have today been accepted by every country on the planet. These conventions and their 3 additional protocols contain a vast array of provisions. Essentially, however, all their different articles are variations on just a few fundamental rules. Spare civilians. Spare the wounded and sick. Spare people who are detained. When the members of fighting forces fail to draw a distinction between the civilian population and military objectives, the result is an endless, terrifying cycle of reprisal and counter-reprisal. Civilians taking no direct part in the hostilities must be spared by the belligerents at all costs. Under no circumstances may they be targeted. Failure to obey this fundamental rule too often forces people to flee their homes with all the pain and uncertainty this brings.
Unfortunately, what we've seen in the last couple of decades is that the main victims of armed conflict are civilians, men, women, and children. That the idea of war between two armies who line up on a battlefield and fight each other is long past. Now we see that up to 90% of the casualties of modern warfare are civilians.
Sparing the wounded and sick, whether civilian or military, whatever side they belong to, is obligatory. As Henri Dunant always stressed, a wounded soldier is a non-combatant. But sparing the lives of victims isn't enough. First aiders, ambulance staff and hospitals must also be protected. The distinctive Red Cross and Red Crescent emblems, and more recently the Red Crystal, exist to safeguard medical activities. But ensuring that protection is, alas, difficult. Making sure that no harm comes to people who are detained is an essential principle of the Geneva Conventions. Captured combatants and civilians in the hands of the enemy are entitled to respect for their lives and dignity. They must be protected from all forms of violence, especially torture. They must also be able to maintain links with their families and to enjoy fundamental judicial guarantees. In war, you cannot do whatever you please. Humanitarian law bans the use of weapons that are indiscriminate or cause excessive suffering. After a long campaign, anti-personnel mines, which go on maiming and killing long after the last shot has been fired, were finally banned by the Ottawa Convention of 1997. Today, humanitarian concerns are focusing on cluster weapons. But even if there is progress towards banning cluster munitions, what even more insidious weapons may appear tomorrow? Serious violations of the law can lurk behind expressions such as surgical strikes and collateral damage. The warring parties must take all possible precautions to confine their attacks to military objectives and to forego operations that could cause excessive incidental civilian losses. The principles of distinction, proportionality, and precaution are extremely basic, but sadly not always respected. Since the 11th of September 2001, there's been a polarization in international affairs, and today's world has many new tensions. Both terrorist networks and programs to fight those networks have destabilized entire regions. The rules of humanitarian law apply to new forms of conflict as they arise, and provide a basis for meeting today's challenges. The validity of humanitarian law is sometimes questioned by this or that political or military leader. And when it isn't being totally flouted, the law is often poorly implemented, or it is quite simply unknown to those who are supposed to obey it. It's important to make all those engaged in armed conflict aware of their responsibilities. These parties naturally include states, but also other entities. The rules of war apply to everyone. There are no exceptions. Conflict is not the preserve of the states. Weapons are also wielded by rebels, and also these days by private security companies, whose frequent failure to comply with the law is a serious problem. But little can be accomplished if there is no contact with the groups concerned.
It is very important that the ICRC should put in more effort to speak to them as soon as they have been identified, go into their camps and try to educate them on the law of armed conflict.
Ignorance of humanitarian law is something that must be fought. If people don't even know the rules they're supposed to obey, compliance with the law is impossible.
These rules are taken from international conventions that your own country has signed. Everybody has a right to be cared for when he or she is wounded.
If humanitarian law is to be respected, then every state must incorporate its content into its own law and military doctrine.
Nosotros trabajamos del futuro, del 97 en adelante. Y nuestra labor es así, o sea, es difundir y aplicar el derecho internacional humanitario para dar a conocer esta normativa con el objetivo de prevenir los errores y los horrores que se cometen durante el conflicto armado.
The law has to punish those who violate it. Without penalties for non-compliance, how can humanitarian law be effective? A person suspected of having committed or ordered grave breaches of the Geneva Conventions can, whatever his nationality, be prosecuted, either by the national courts of any country or by the international court. That court, the International Criminal Court, is based in The Hague. It's an independent standing body before which individuals accused of the most serious acts, genocide, war crimes, and crimes against humanity, are tried. Over 100 countries have ratified the statute of the International Criminal Court, but this is nowhere near enough.
International criminal justice has an important function to end impunity. The tribunals have a very important dissuasive function. I wish, however, to point out that we are just at the beginning of a process. Lots of progress has been made over the past 10-20 years in developing international criminal law and international justice. However, we are just at the beginning of the journey. There's still a way to go before we have a system at the national and international level that counters acts of barbarism amounting to international crimes.
The rules of humanitarian law are of capital importance, and they are effective. When respected, they safeguard civilization as a whole. That is why it is vital for each of us to embrace and apply those rules. Despite all the strains on the system, humanitarian law is a reality. And it is capable of protecting anyone made vulnerable by war.
Any questions? I think we have gone through international humanitarian law very thoroughly and the resolutions of International Court of Criminal Justice, but then also,
What's the abbreviation of ICRC?
International ICRC, International Red Crescent, ICRC. Committee for Red Crescent. Red Crescent, it was Red Cross before, and now also there is another one. Red Crescent.
So, for which region is it applicable?
Whole of the world, yeah, globally. Globally.
We know that Muslim countries usually use red crystals. So, for red crystals, which region or which group of people use?
I'm not sure about that, but red crystal is, I think Zubair can help me on this. Red crescent is, for Muslim countries, red crescent there. And Red Cross was before Red Crescent came, Red Cross was there. But ICRC is similar. And I don't think, it is crystallization of this part should be that, or there is any discrimination between Red Crescent, Red Cross, or anything else. Yeah. Yes.
I have a question. That is, some years before there was a battlefield. People do war there, but nowadays they do war in the civilian areas. But the technology is now in a super high position. So why don't we choose a planet like Moon or something where they can war and the civilization is safe?
Yeah, that is a very good proposition. To have a place of war, a place where war can take place, so that it doesn't affect the civilians and doesn't affect other people who are non-combatant, who are not in the battlefield, who are not fighting the war. That can be, a very good suggestion, I think. But people don't think like that. People think, when they are enraged, they're in war, they want to finish, they want to see change, and they want to do autonomy. So I go back to what Professor Monsour was saying about autonomy. This is also one type of autonomy, which is still, why we are educated, we have tolerance, we have patience, we have, love, and we have all the qualities. Then also we could not go out of war. We could not go to, say, a war within the family, domestic wars, domestic violence. We cannot go out of that. Why? What is the use of this education then? I think we did not go away from the Stone Age. We are still in the Stone Age, in the sense that we did not improve or empower ourselves on our ethical considerations and values. And that is why this Bangladesh Bioethics Society is a very good forum where we can really upgrade ourselves to our ethics, morality, love, and all these attitudes which are there, the attributes which should be there as a human being. A human being becomes an animal. Say, if you do not follow the rules, you don't have a borderline. Say a husband and wife, if they do not follow the rules which should be there, trust, then you become an animal. You go and have sex with anyone, and then you come back. You don't have that trust anymore. So these things has to be made, in the media. The awareness building should be there, so that people understands the virtues, the values of life, and to give what Professor Daryl said rightly, heroes, the good life. A good life, to give good life, you must be a good human being, and you must respect others, other human beings, and their rights. And even in war, this international humanitarian law is saying, even in war you have limits. Even in war you cannot do what you want. There are limits about wounded, about the persons who are not combatants anymore, non-combatants. So these are the things which should be highlighted in our societies. Globally also we need to say to the people that, look, this is what we need to do. A place where you go and do the war and come back. Can be, as the Anna would say, the moon or somewhere else. But don't spoil the whole civilization and our globe. Let it be the safety and protection of our people for the future generation. We have to do this. Thank you, everyone. Any other question or comment? Yes.
Why these your international laws are affected in the war when war is going on? Or I'm seeing in Bangladesh situation after 40 years it's going, the law process is going for the
criminal actions.
Going.
For criminal law, there is no limitation. You will be punished whenever whenever you are tried, you will be punished. So for civil law, there is limitations, but for criminal law, there is no limitations.
But after 40 years, what's the difference between because now Bangladesh and Pakistan is now friendly? Why making like this? Like they are our enemy, still our enemy. But they are not enemy now.
But they did, if they did any wrong, you according to the law, you will be punished.
At that time, in wartime, why not?
No, at the war time also you should have been punished after the war. But they did not do that. That was a thing of politics which we don't want to discuss here. I think it is really a politics and that is ruling the world. What we cannot go out of our self-interest, we cannot go out of our political interest and look into the world as a world of a dream, of a world of a peace where we can all live together peacefully with the virtues of ethics and morality. Thank you so much, everyone. Thank you.